Have you ever thought about what happens to your data when you die? I mean, I'm guessing we've not thought about it a lot, but this was something that was brought up before a court in Gujarat. And they basically said that people can inherit your data. And in this particular case, they treated data backed up on the iCloud as a movable property that can be inherited.
Yeah.
Before we get into the case, what all do you store on your iCloud or just cloud in general?
I mean, I think pretty much everything I do in some form is on the cloud. It could be my chats with people, there are backups of chats on the cloud. My phone, for instance, has Google Photos, so I'm sure there are images and videos that have been backed up, audio files, some personal files, some files for work as well, because we all tend to back up something or the other so we can retrieve it later.
Yeah, I think we've all had to learn it the hard way that relying on your device is not the best idea, and so we tend to back up most things that have any remote value at all. But interesting what you just said about inheriting data, because even the DPDP Act talks about it provides for a nominee, right? You can nominate somebody to take care of your, or at least be entrusted with your data once you pass away. And that just brings us to a very important question. And because we're on the topic, I thought about whether I'd be comfortable sharing all of my data with one person. Who would that one person be? I thought to myself, because I don't want my parents to know everything, every last thing about me. Neither do I want. I mean, I can't think of anyone.
One person.
Who should know everything.
I would have to blame it on your trust issues, but even I cannot think of anyone. But yeah, for example, this podcast will get backed up on the cloud. And what happens then? If we discussed something that is not published on YouTube and we've cut it out, we don't want it to be shared. Do people then get access to it after I die?
And that's a particularly great example because it brings two problems to the fore, right? One, of course, is what you said. What you implied that we may end up discussing some work-related proprietary information, which is not for the world to access or know. And because it is amongst the three of us, it's okay. But once, your next of kin, suppose, gets their hand on it, they're not legally obligated to keep it to themselves. So they can do whatever they want with that information. And the other thing is that this podcast doesn't just have one of us.
Right.
So it has the three of us, and I'm or Shweta, we might not be comfortable with the idea of your next kid, no offense, having access to a video or any information about us. Because that's not particularly something that we've consented to.
I mean, that's the broader flaw with this court's order. So in this case, basically what they said is this person does not have a nominee, etc. And so the family basically wanted access to iCloud because they said, there are a lot of photos, it's got a lot of sentimental value, etc. But in real life, a lot of our personal information isn't about just us. It implicates other people around us. And then an image of me and you, for instance, has both our rights of privacy baked into it. How does that kind of work with a nomination mechanism? And that's why data is not like movable property in general. It's not like my phone or my laptop. In that case, I own my phone, I own my laptop. There's no real question, there's no real doubt. But something like this differs significantly because two people can validly claim that they have ownership over it. So how are you going to decide how this works? And then similarly, the conflict with proprietary rights, as you said. Because say there is a work file, there may be some personal information about me, some metadata on the file or whatever, or maybe the file itself has some information about me, but it will also certainly have some information about the work we're doing. And so how are you going to then decide the kind of order or hierarchy of these rights? Normally in tangible property, it's very possible to have one owner, but this is layered ownership. And then also just the sheer volume and kind of variety of data makes it so different, right? And normally any tangible property, even if you have a lot of it, say you have a lot of shoes or you have a lot of bags, you can still ultimately count them and then kind of decide, okay, these are all the bags and shoes that belong to this one person. With data, just think of the footprint you leave on a daily basis across several services and over time. So if say tomorrow some heir of Chhavis gets access to our information, just think about the period of time over which that kind of information has accrued and just the sheer variety of information that then goes in. It becomes virtually
impossible. If I want to decide who gets what and essentially decides, say, I want some of the photos to go to my family, some of the photos to not go to my family, go to some other person. In that case, do I have to then keep track of everything that I'm doing on the cloud? Do I have to make note of any purchase I make that's backed up to the cloud? Any like in-device, in-app storage that I'm utilizing on the cloud? It's impossible to
And
humanly
also,
keep track of all of that.
operationally, how would that work, right? And because the law technically will provide for one, maybe two people to have access to. But like, if you want separate people to have separate portions and segments, and like you know, bake it into your will, how will it work? Because we haven't had any precedent on how to go about this. I think it's an interesting question.
The nomination parallel in other contexts doesn't work because of what you said. It's a little finite. So say we all have bank accounts, so we've all had to appoint a nominee for our account, and that's a little easier. One, you are more likely to know who you want to have your financial information and ultimately your money go to if something happens. It's something people are just generally more aware of, and also your bank, like there is a certain amount of money in there. The bank knows what's there. It's a little simpler to navigate because it's limited. The scope of information is limited. Exactly. But then, like you're saying, the range of personal data is so vast, it's really hard for you to first decide who it should go to. And even that nomination mechanism, I'm sure, can get tricky. So I think even the offline parallel, though we do have nomination in other contexts, it doesn't hold well in the context of data.
I mean, remember, Shani, we were talking about this case, the German case, where this is, I think, from 2018, where a father had filed a suit seeking to retrieve his daughter's Facebook account because she had passed away. And from what I recall, the German High Court, Supreme Court actually, ruled in favor, and then he was finally given access to the account because he rightfully had a claim over it. So I think like there's very far and few cases so far, because I mean again, technology is still evolving and we're still figuring out how to go about it, and what the rights around it are also evolving still. But I think that this judgment is a step in some direction. I don't know if it's the right direction yet, but it's definitely starting a conversation. It's gotten us to think about what happens to our data when we die.
I mean, I think what this judgment has done, if you see the text, it relies on a lot of laws, like say the Sale of Goods Act and the IT Act, and it just says that this in the understanding of movable property in all these laws is wide enough that we can include digital assets, which maybe is correct. You can debate whether the flexibility.
Something like a NFT makes sense. Something like data is too broad. Because with property, then you're saying it has the bundle of rights associated with it that says you can modify the property. Can I modify a picture of you that might be in my cloud storage?
Right.
Can I then transfer it to anyone? I think that is also problematic. There's a need to create that distinction between something like a NFT and data in general.
Yeah, and that's what, like the court does not seem to have considered the broader ramifications of saying this, because it may have just looked at the letter of a statute and said, hey, this can be constructed in this way. And in this particular case, maybe it's a happy outcome in that there is no real contestation. But in future cases, if this is the precedent that holds, there may be situations where your data going to a legal heir may not be ideal at all. And
I mean,
could be much more fractious.
There are some cases that we earlier remember we were thinking about. For example, in the case of an acrimonious death, and like it gets transferred to your partner. Now, if that death itself is contentious, right, and your partner has access to all your data, that can be used very conveniently to change the narrative, or to even weaponize against the victim. I mean, not even just the victim. Sometimes, let's say there is something like this, a kind of suspicious death, if you will, and there is information like a chat backup that goes to someone else. Those chats aren't only about me, right? It could also implicate a living person in real time who's not been asked to, like, obviously, who does not have then control over this, who may not have even known that personal information about them.
This is something the judgment has missed, because they've talked about right to privacy in the context of the person who has died, and they said that the right dies with them. But what happens to the right to privacy if everyone whose data is lying on the cloud?
And I don't think they seem to have addressed that conflict, it's something, again, because they've not thought about it from a wider lens possibly, and maybe again you're constrained by the facts of a case before you. But in future settings, this kind of holding can be really contentious on multiple